Your Excellency Prime Minister, honorable members of the Cabinet, distinguished colleagues, my name is Sabra Mustafa Ismail, and I'm honored to serve you as your legal advisor this afternoon. Today, I will be providing an in-depth analysis and recommendations regarding the state of Mandalore's potential accession to the International Covenant on Civil and Political Rights, which I will be referring to as the ICCPR throughout this presentation, and its first optional protocol. This presentation will address the implications of these international commitments to Mandalore, whilst also suggesting about making a reservation to Article 1 of the optional protocol. To begin, we must acknowledge that the ICCPR has come a long way from what it is now. The Covenant was adopted and ratified by the General Assembly Resolution 2200A, December of 1966. 10 years later, 35 countries became a party to the Covenant and entered into force in those 35 states in 1976. Its footing, however, dates further back than its adoption. The ICCPR was part of efforts that began in 1948 with the Universal Declaration of Human Rights Bill, which aimed to create a thorough and extensive Bill of Rights. However, these efforts were stalled due to the tumultuous events of the Cold War, which saw a divide in ideological preferences between the West and Soviet bloc. While the West emphasized on civil and political rights, the Soviet bloc was far more in favor of economic and social rights. Then, in 1952, there was a creation of two treaties that addressed these preferences, with the ICCPR in specific meant to address rights to life, fair trial, equality, protection against violence, and freedoms of expression, religion, and assembly. The ICCPR then requires that states are bound to the rights that it enshrines. Mandalore can expect various advantages and its importance in becoming a party to the ICCPR. The treaty allows the state to promote democracy by promoting human rights, applying the rule of law, and limiting state power abuse. This is specifically necessary for Mandalore, as upholding these factors, it promotes a more politically stable country that in turn fosters citizens that also embrace progress and post-materialist values, such as protection of other citizens against human rights abuse. Additionally, ICCPR is relevant to the state of Mandalore, as being a party to the treaty allows credibly committing to citizens that the promotion of human rights is prioritized by the state. Becoming a party to the treaty fundamentally enhances Mandalore's human rights framework. So much so that, in support of ratification of the ICCPR, Keith found that state parties often have a better human rights record than non-state parties. It is also important to note that politically, Mandalore can further strengthen its international reputation by showing that the state is fully committed to enhance human rights by international standards, which allow better diplomatic relationships with other parties of the treaty. While advantageous, the process to ratify this international treaty can be a slippery slope, and it is necessary to understand the principles of it through an analysis of theoretical views of the impacts of the human rights treaty ratification. Ratifying human rights treaties usually means that states are required to align their domestic laws with international standards, which could equate to a loss of sovereignty. This can be seen with the US's refusal to ratify the first optional protocol to the ICCPR, which leaves citizens to rely on domestic protections instead, as many countries similar to the US feel as though ratifying such a treaty may pose a threat to the nation's sovereignty. Now, the first optional protocol to the ICCPR is also an international treaty that establishes an individual complaint mechanism for the ICCPR. It allows individuals whose countries are party to the ICCPR to lodge complaints should they discover that their rights under the ICCPR have been violated. This mechanism, however, requires that these individuals first exhaust all domestic remedies before bringing their case to the UN Human Rights Committee. As it states in the name, it is not mandatory for states to be party to the optional protocol, but once it becomes a party, then the state is bound by the articles the treaty provides. Similar to the ICCPR, the first optional protocol to the ICCPR was adopted in 1966 and entered into force in 1976 in accordance with Article 9. As aforementioned, in order to achieve the goal of the ICCPR and the implementation of its provisions, it was only appropriate to set out the Human Rights Committee to oversee communications from individuals that are claiming to be victims of violation of the rights proclaimed in the Covenant. The first optional protocol to the ICCPR made several key provisions to guide complaints made by any person who is subject to the state party. I'll be focusing on Articles 1 to 5, which, in my opinion, give crucial guidelines to provide additional mechanisms for the enforcement of civil and political rights. The articles focus on rights of individuals and to submit communications, the criteria for admissibility of communications, and the process followed by the HRC in reviewing communications. Therefore, Article 1 requires that states that are party to the protocol must recognize the competence of the Human Rights Committee to receive and consider communications from individuals who claim that they are victim of violations of the rights set out in ICCPR. Article 2 states that individuals must exhaust all domestic remedies prior to lodging a complaint to the HRC. Article 3 requires that the committee will consider communications inadmissible if they are anonymous or abusive. Additionally, Article 4 requires that once communications are lodged, the committee will notify the state party concerned, which then in this case, Mandalore, will be required to submit a written explanation to clarify the matter within 6 months. Finally, in Article 5, it states that the committee will discuss and examine the communications in a closed meeting, then forward its views to the state party and the individuals. The implications of Mandalore and becoming a party to the optional protocol allows for enhanced accountability for human rights violations. This is evidenced in the case of Tunen versus Australia, where the complainant brought a communication before the HRC to challenge sodomy laws in Australia. The complainant challenged the state of Australia under Article 17 of the ICCPR, which talks about the right to privacy. He also invoked Article 26 to talk about discrimination on sexual orientation. The committee then agreed that Australia was in breach of the obligations that are set out in the treaty. This case led to the repeal of Australia's last sodomy laws. I say this to show that the optional protocol allows for individuals to challenge the violations of the rights that are set out in the ICCPR, which in turn allows a country like Mandalore to have more accountability for what one could argue to be fundamental rights. Similarly, the case of Bra versus Australia 2006 showed that the complainant, who was 16 years of age, challenging inhumane treatment from the state prison, where the HRC ruled that the state was in violation of Article 10 of the ICCPR, which sets out that all people should be treated with humanity and integrity. The HRC also found that the state was in violation of Article 24 of the treaty, where it specified that children should have the right to protection by the state. The UN also made a comment that to state that once a state party is found to be in violation or breach of obligations set out in the ICCPR, then the state party must ensure that similar violations are not to take place in the future. Now, when discussing matters of reserving international treaties, it is important to understand what reservations are. Section 2 of the Vienna Conventions of the Law of Treaties, which I will be referring to as the VCLT, defines reservations as a declaration made by a state when signing or ratifying a treaty that it reserves the right not to comply with certain provisions of that particular treaty. Reservations allow states to use this system to relax obligations that would make ratifying a particular provision too costly. The VCLT treaties regulates treaties among sovereign states and has made regulations and guidelines on reservations. Specifically, Article 19 of VCLT says that a state has a right to make a reservation when signing or ratifying a treaty unless the reservation is prohibited by the treaty, or if the treaty only allows certain reservations which are incompatible with the reservation that the state is trying to make. It also states that reservations must be compatible with the object and the purpose of the treaty. Reserving the first optional protocol might show some advantages to Mandalore. Reservations pose a necessary instrument in a country retaining their sovereignty whilst ratifying a treaty, which allows states to exclude certain obligations of the protocol that conflict with domestic policies or constitutional principles. Therefore, for Mandalore, it may be necessary in order to allow some domestic laws that do not align with the optional protocol to be excluded in the compliance of the treaty. In Mandalore's case, there may be some challenges when reserving Article 1 of the first optional protocol, as the purpose of the protocol is to allow individuals of Mandalore to seek redress for violations. As per Article 19, reservations cannot be made if they're contrary to the object and the purpose of the treaty, which may make it unacceptable under international law. While the ICCPR and the first optional protocol haven't made any express mentions that prohibit reservations made to the provisions like the second optional protocol has, it is important to keep in mind that the implications of making reservations to Article 1 of the optional protocol. As expressed in the general comments made by the United Nations, the absence of a prohibition does not equate to reservations being permitted. The general comment also stated that reservations to a substantial obligation would make an impression that the state is concerned with preventing the committee from making its views on an individual case. Your Excellency, Prime Minister, it is of my belief that Article 1 of the optional protocol would constitute a substantial obligation, and making a reservation to it could lead to making an impression that an individual's rights are limited in enforcing them within the ICCPR. Politically, there may also be drawbacks from other state parties who may object the reservation, which can lead to hurting the diplomatic relations that Mandalore may have with other states. Furthermore, Article 1 is crucial as it allows individuals to seek justice on an international level and allows their rights to be protected. It is important as it holds state parties accountable if they're in violation of the covenant. Therefore, it is within my belief that the Member of Cabinet's suggestion to make a reservation to Article 1 of the protocol may mean that Mandalore is opting out of allowing individuals to file complaints directly to the committee. It may further mean that Mandalore is undermining the goals of the convention as well as the protocol, which again may undermine the HRC's role in enforcing compliance to the convention. This could all potentially lead to citizens of Mandalore losing trust to the government's commitment of upholding their individual rights. As an example, the state of Trinidad and Tobago, upon re-acceding to the optional protocol, decided to make a reservation on Article 1 of the optional protocol and declare that the committee cannot be competent enough to receive communications that are in relation to any prisoner that is facing a death sentence. The UN HRC in the General Comment 24 mentions that reservations to the ICCPR an optional protocol may undermine the effective implementation of the covenant and weaken the respect for obligations of state parties. This generally applies to reservation of most human treaties. Additionally, the case of Kennedy versus Trinidad and Tobago, the matter of reserving Article 1 was found to be problematic in its enforcement. Your Excellency Prime Minister, it is of my belief that it is necessary to ratify the ICCPR in the state of Mandalore, as well as the first optional protocol, without making a reservation of Article 1 of the first optional protocol, given the drawbacks that I previously stated. This way, it can allow for Mandalore to effectively adopt a better and more robust human rights framework without undermining the purpose and object of the optional protocol, as well as the Human Rights Committee. Your Excellency, shall you find that Article 1 of the optional protocol may be incompatible with the domestic laws of Mandalore, then I urge you to consider the possibility of not ratifying it at all. Should you have any more questions, Your Excellency, please feel free to ask. Thank you very much. Have a very good afternoon.